Good morning, guys. It's Kathy. Hope you're doing well. We made it to, Monday. Oh, I'm always shocked when it's Monday. I don't know why. I have 7 days to warning, but it is Monday. It is time to start the week. I hope last week was good. We're going to stay in Colorado again today, which we've been doing a lot lately. I need to stop that, and I'm working on it. Don't worry. All right. I hope anybody who is trying to walk on a brand new knee today doesn't have any pain. That's just what I hope. Maybe. Oh my God, it's Bill. Bill, I miss you. Look, guys, it's Bill. When I get my camera back, Bill, you're gonna have to hop on a stream with me. Everybody would love that. All right, let's get to work. Let's press play.
Thank you for your patience, Judge. Mr. Voss appears out of custody to my right.
Okay, thank you, Ms. Johnston. Good morning, Mr. Voss. I know you are being pulled in about 25 different directions at once, Ms. Johnston, so we understand. All right, this matter is set for motions hearing today. Testimonial motions have been filed. Motion to suppress for lack of reasonable suspicion, lack of probable cause, and to suppress statements as involuntary. Are those the issues that we're litigating, Ms. Johnston?
Yes, Judge, and I think the purported Miranda waiver is involuntary, so yes.
All right, so that becoming the voluntariness of statements.
Thank you.
Sure. All right, people ready to proceed?
Yes, Your Honor. People call Officer Wilkerson to the stand.
Thank you. Like a legal pad down there somewhere. Or... You raise your hand.
Yo, never mind. Hold on. I was going to say, Officer Wilkerson again? That's crazy. No, it's not.
Absolutely he's going to join
There
us.
we go.
We'll just watch from really close on our screen here. Have a seat.
Thank you very much.
Apologize for that.
No, you're fine.
Let's see. Yeah, he was here. He might just be next door. He has quite a few cases, doesn't he? Mr. Sinesco, which case is yours?
I'm here on Ms. McMillian.
Oh, okay. Don't see her just yet.
Yes, Your Honor.
Okay, so we'll wait a minute on that. Well, we have Miss Way. Okay, let's call case number 25 CR 5001, People of the State of Colorado versus Sarah Lucille Way, and we are here for a review. Miss Counsel Schamberg is appearing on behalf of and with Miss Way and Mr. Sides for the people. Counsel, looks like our report's due July 24th.
Yes, and so she is also actively in treatment at the Colorado Mental Health Hospital in Fort Logan.
Good job.
Understanding our report, we might have a report in July based off the latest reports we've gotten from the hospital. I think it is likely to come back that she is still incompetent to proceed. We can set to August. I would be asking for a 90-day set over. She is on a no bond hold out of an extradition case from Mesa. But I think if we want to set to August to see what the report says, that's fine.
Okay.
But I don't think there's going to be a big change in circumstances.
Mr. Sides.
That's fine if we set to the August date, Judge.
August, okay. All right, Miss Way, what we're going to do is have you come back. We should have your report back by then. August 11th at 1:30. And you can appear by WebEx like you've done today. Just be the same access code. You just give us a call.
Okay.
And then we'll have more information at that time.
Okay, thank you.
All right, you have a good day.
Yes, you as well.
Thanks.
Judge, my mind's drawing a blank. Do we need a WebEx for it when they're at Fort Smith? or for law enforcement.
Yes.
Because, yeah. Yeah.
Oh, we've got Mr. Fyrix. Counsel? That's you. Okay. The court's going to call case 26R10, 25M39, 25M46, 25M50. These are all Yuma County cases. 26M5, People of State of Colorado versus Corey Dean Fryrich. And we are here for a review. Counsel Schamberg is appearing on behalf of and with the defendant who appears by WebEx. Hi, Corey. How are you doing today? Corey, can you hear me? Mr. Fryrich, can you hear me? No, I don't think you can. Corey? No, and we have Mr. Science for the People, but we're having some technical difficulties with Mr. Fryrich's. I can see him. Oh, there you go. Corey, can you hear me? Corey?
That's how my son is, guys. It feels like I'm talking to my son. Hi, V.
Should we pass his? All right, we're going to pass on his cases for just a minute because he cannot hear us.
Okay.
So sorry about that. I'm just not seeing the people that I should be seeing. Okay, Mr. Hernandez, we'll call your case.
V, thank you so much for the Twitch subscription. I really, really, really appreciate it.
Court will call case 22 CR 5010. This is a Kit Carson case. People of State of Colorado versus Chato Hernandez. We're here for a review. This matter comes before the court for, again, a review. Counsel Schamberg's appearing on behalf of and with the defendant who appears by WebEx with authorization from the court, and Mr. Sides from the people, for the people. Counsel.
Yes, Your Honor. Mr. Hernandez is at Valor and participating in treatment. We do need the court to issue a reevaluation. I think it's time for another one. We are asking for a 90-day set over.
Very good. Mr. Sides?
Thank you, Judge. I did mention to the defense that perhaps if we could find some type of civil commitment, that might be something we'd look at in this case. So, but that obviously will take a little bit of time to try to work out.
All right, very good. Okay, Mr. Hernandez, I'm going to get an order for another evaluation. We'll have you schedule you back in 90 days. So that's going to be October 13th at 1:30. And you can appear by WebEx, just like you did today. And how are things going at Valor? 13th. Yep, things going well for you, sir?
That's what I'm actually going to tell you is, so I was from Baylor, and I'm in,
Okay, I'm glad you told us this.
hold on.
Okay, holding on. Okay, I don't know who you're talking to, Mr. Hernandez. Mr. Hernandez, where'd you go?
I'm back.
Okay.
So it's called Superior Connections, and it's a sober living.
So where are you? You cut out a little bit. Tell me again where that was?
It's called Superior Connection, and it's sober living.
Well, I sure do appreciate you telling me that. That's not in the information that we have.
I'll reach out to Valor. They're normally really good about
They normally are really good
telling
about it.
us. Yeah.
They should pay me for that stellar ad that Mr. Hernandez just placed for them. We all want to move there now.
Mr. Sides,
I haven't heard any other information, though, but we should figure out where he is at and
maybe we should check in August.
to August, yeah.
Yeah. So, Mr. Hernandez, we're going to change your court date. Appreciate you telling us the information. Your video connection goes in and out, and so does your sound, but I think we should have you come back August 11th at 1:30. Okay? Because we need some more information from Valor about what's going on with you, sir.
Okay.
So August.
That'll be fun, Judge, because I'm thinking Valor's never heard of him before.
August 11th at 1:30. And then your attorney is going to reach out to Valor and we're going to find out what's what, okay? Any concerns about today?
Okay.
Okay.
He
all right,
thought
good,
you
good, good.
said
All right, well, you keep
Valor.
up the good work, sir. I'm really pleased to hear that you're in sober living. Good job. Outstanding.
Thank
Good job. Proud of you. Okay, we'll see you in a month.
Okay.
Okay, bye-bye.
Bye.
I'll still get the reevaluation ordered. Hi, Mr. Fiddler. Mr. Fiddler, can you hear me?
I'm going to look up real quick. I'm going to open Temu and look up sober living and see what pops up. Maybe they have a Temu sober living.
Good morning, good afternoon, Your Honor.
Hi there. Oh, very good. Okay, Mr. Fiddler, got a couple cases with you. Mr. Torres, come on down. Court's going to recall case 2016-19, 25M85, 26M6, People, State of Colorado versus Paul Torres. We're here for our review. Mr. Fiddler is appearing on behalf of and with the defendant, who is here with us in person, and Mr. Sides for the people. Mr. Fiddler. Doing great, Mr. Torres.
Your
Thank
Honor,
you.
I think we're still working on the competency issues, but I'm sorry, Your Honor. Can you hear me okay?
We can. Mm-hmm.
Okay, I'm sorry. So I think if we could just set it over, I would appreciate it and follow up with Mr. Torres. I saw him in court this morning, seems to be doing well, but just like to set it over and see where we go from there.
Set it over to when?
Judge, if I may, and forgive me, Mr. Fiddler, I'm jumping in on you here.
Yeah.
We have a report filed by CDHS on June 25th saying they don't think the report will be provided to the court until September 5th. So we should maybe go to our September date.
Oh, that's when the report will
That's when
be.
they say they'll have the report for us.
Oh, that's right, September 5th. Okay.
Never disappoints. Never disappoints. Yep. I got a dress that looks like baked beans when I typed in Temu sober living. And it's only $15. Guys, I call this an investment in my future, actually. I don't even call this a dress. This is how we win the world or the internet. We win the internet if we purchase. That looks like baked beans, right? My eyesight is real bad, but if you want to buy some sober living, I would carry around 2 pieces of toast if I wore that dress, and then everybody would think that I was British or Scottish, right?
So it looks like we'll get our report on September 5th, so we could do the September court date. How's that sound, Mr. Fiddler?
That's fine. When is that, Your Honor?
Good question. Let's get that.
I think it's September 8th, Judge.
That's right. September 8th at 1:30. You can appear by WebEx, Mr. Torres, but just here, you're just doing great. So keep
Thank you
up the
very
good
much.
work. Good
God
job.
bless. Yep.
Yeah. How are you feeling?
I feel good,
Good.
but I missed court this morning, but
You missed court this morning? Are you in trouble?
because I went straight to work and I spaced out here and it's not even working because I don't get paid for it, but I'm cleaning up one of the apartment complexes here, the Burlington Manor, and I'm doing that for free as because I'm HIV positive 18 years already, and it's hard for me to get a job here. I put in everywhere, and
Okay.
so I just decided, might as well donate than not do nothing.
That's
That's what I'm doing.
well said. So no.
I worked for Dan Green for a while,
Uh-huh.
and I got pulled over on a vehicle that wasn't mine. They took it away, so I stopped that.
Okay. Good job. Yeah. Stop that. All right.
Yeah.
Well, I'm glad to hear you're doing
I haven't had
okay.
my license in 30 years. They
yeah?
took it away when I had just turned 18
Oh,
for
ouch.
1 year, and I haven't got it back.
And for 30 years? That's a long year.
Yeah. It's a long year, So, but I could get it back whenever now.
Good.
Yep.
Work on that.
Yeah.
Okay.
God bless. Thank you, guys.
All right. Thank you, sir.
Yep.
September 8th, 1:30. Thank you, Mr. Fiddler.
Thank you, Your Honor.
Can I get a car?
Do we have a reminder?
And stay off the
Yeah,
roof.
we can get you one of those.
Okay, I got it. Oh, you got one.
Thank you.
And I'm sorry, what's the date?
September 8th at 1:30.
And Your Honor, I apologize. Could we take Mr. Stroop's case? I'm in court in Ray, so I apologize for the interruption.
Yeah, no, that would be fine.
Good question. Thank you.
Thanks, Mr. Torres.
Ah.
Thank you.
I don't know any Ray courtrooms. I can't get them. Psh.
God bless.
Okay, Mr. Stroop, let's see. You're with us, aren't you? Court will call cases 25T68, 25CR18, 25M23, People of the State of Colorado versus Levi Stroop. We are here for a review appearance. Mr. Fiddler appears on behalf of and with Mr. Stroop, and Mr. Sides for the people. Okay, so it looks like we're going to get the report on September 7th. Mr. Fiddler, I see that there's other filings, but I can't address those until I get the report done where we resolve this issue.
And Your Honor, I did not file those.
Oh. Who filed them?
Those were filed by Cheyenne Maggard.
Who's that?
She is, according to my understanding, Mr. Stroop's mental health companion. Although looking at the filings, she
Oh no. Guys, my eyesight is really bad. And when I was getting this together, I thought it was a mental health champion, not mental health companion. My thumbnail may or may not have the wrong word on it.
now appears to be a CNA. I do not know why the filings were accepted. I did tell Mr. Sides about that. I did tell Mr. Fletcher or Ms. Fletcher that things were filed in the case. I don't know why they were accepted, but they were accepted.
So, Mr. Stroop, actually, you have an attorney. Your attorney is the only one who can file things on your behalf. If other people file on your behalf and they're not an attorney, they can actually get into a lot of trouble for unauthorized practice of law. That's a crime. So you don't want to encourage people to file things on your behalf. So I'm not going to take any action on anything that's been improperly filed. I just need you to understand that, okay? That makes sense? Can you hear me okay?
Yes, I can hear you.
All right, very good. So if someone thinks that they're doing good deeds and filing on your behalf, tell them not to. making you have an attorney, and I don't want that person to get in trouble. Okay, make sense?
Okay, Your Honor.
Okay. So we're going to get your report on September 7th. So, Mr. Sides, did you want to make a record?
Judge, my only concern is the same as Mr. Fiddler's, why those filings were accepted, but that's kind of the moot issue, I guess, at this point or so. So I would just ask that we set the review hearing for September 8th docket.
Okay. Right.
Thank you for
So
the
I'm inclined to
cheers.
just have you come back.
Judge, do not interrupt me. Huh. I wish the judges could mute like I do. Uh-huh. Thank you for the cheers, V.
Back on September 8th at 1:30. You can appear by WebEx like you did again today. Is that acceptable, Mr. Fiddler?
Yes, Your Honor.
We're going to see metal later. We're going to put a payday bar at the end of a room, a long room, a gym, a gymnasium room. And me and Michael are going to race to see who can get it first. He's going to win, though.
All right. All right.
Thank you, Judge.
So make sense, Mr. Stroop? We're waiting for your report.
Yes, ma'am.
We should get
Thank
that
you.
on the day before our court, and then we'll check in on September 8th.
Okay.
Okay. All right. You have a good day, sir.
You too. Thank you, ma'am.
Thank you, Mr. Stroop.
Thank you, Your Honor.
Thank you. Did you have any others, Mr. Fiddler?
No, that's it.
All right. Have a good day.
Thank you. You too, Your Honor.
Thanks. Mr. Siniesko, I think we have your client. Miss McMillian, is that you? Wave your hand for me. Good afternoon.
I don't have a choice, Metal. Timu said so. It's either going to be a can of beans or a payday bar.
Court's going to call cases 26 CR 6, 26 M2, and 24 CR 5001. People of the State of Colorado versus Kiri McMillian, and we're here for our review. Mr. Siniesko is appearing on behalf of and with the defendant who appears in custody in Washington County. And we have Mr. Sides for the people. Miss McMillian, you're looking good. It's good to see you.
Thank you, yes. They got me on some meds and stuff and I'm feeling a lot better.
Oh, I'm glad to hear that. Oh, I'm so glad to hear that. Mr. Siniesko?
Your Honor, unfortunately, the only visit I scheduled with Kiri in the last month, I had to cancel due to an emergency with another client. I clearly need to go out there and talk to her to evaluate kind of her state and see if anything has changed that I can inform up the court.
Emergency with another client. This is the mental health docket. So that emergency with another client. I wonder what happened.
Further, it looks like she is pretty high up on the queue now in terms of being transported.
Number 3.
But also the fact that she's taking medications, I think, is going to put her far ahead of where she needs to be, hopefully, at transportation. So I do want to meet with her and kind of evaluate where she's at now, because perhaps things have changed quite a bit.
I know, but we're going to get her in a good place.
Yes, Your Honor.
So pleased to hear that. Mr. Sides?
Judge, I would just ask to set this on the August docket.
Okay.
Maybe she'll be in CMHIP by then. If not, we can check in with her. We'll have given Mr. Siniesko a chance to meet with her, and we can go from there.
Okay, I think that's a good idea. So things are working in your favor, which is good, Miss McMillian. I mean, processes to get you some services and get you some help. We're going to check back in a month from now. We've got our fingers crossed that you will have been transported to another location that can give you additional help and additional services. One of the advisements that I have to give you is that because you're in custody, one of your cases, the highest charge is a class 3 felony. Just to let you know that if you were incarcerated and in custody for a period of 12 years or more, and the court still found that you were incompetent to proceed, the court would dismiss your case. That's a pretty lengthy time, but we're hoping to have things resolved long before then. But we're going to check in August 11th at 1:30 p.m. And we're going to hope that you've been transported to the hospital. And then we can keep moving from there. How's that sound?
Ma'am, is there any way that they could address my bond?
Then I will be taking her meds, V. Once that happens, let her out.
Because my brother-in-law passed away, my twin sister's husband passed away, and I'd like to be able to go to his funeral. My dad's in hospice. I feel like I'm doing a lot.
Your Honor,
I don't
it
think
makes
so.
more sense for me to potentially file for some kind of a furlough after I meet with Kiri. Kiri, I'm going to try to get out there either, well, late this week, probably Friday, okay, if I can set up that appointment again. Hopefully we can meet, and if we need to file something, I'll file something on your behalf, okay?
Yeah, and we couldn't be able to, we wouldn't be able to address your bond today. Your cases are VRA cases. And so your attorney understand what that means. So he can talk to you about that, okay?
Okay, what does that mean?
That means they have to give notice to the named victims in the case. There's a process that goes through. I couldn't address bond today.
I would ask that we set that August date for bond. Again, hopefully Ms. McMillan will be transported by then, but in case she's not, we could take up bond at that point. The district attorney could provide notice to the.
Will do, Your Honor.
Yep, sounds good. All right, August 11th, 1:30.
Thank you, Your Honor.
Thank you. Mr. Fryrix, can you hear me yet? Corey?
Yes,
You
I
can hear
can.
me now? All right, good. Let's recall cases 26R10. These are Yuma County cases, 25M39, 25M46, 25M50, 26M5. People of the State of Colorado versus Corey Fryrich. And we are here for a review. Counsel Schamberg's appearing on behalf of and with the defendant who appears by WebEx. Mr. Sides for the people. Counsel.
Yes, Your Honor. The report has come back finding Mr. Freerichs competent to proceed. Our office is not objecting to that finding. We are asking to set back into division. I was just talking with our Yuma County PD. The next court date bears July 22nd for the next public defender county court docket day.
What time?
Great question. I just asked him that.
It's
Yuma.
Yuma. We've got it. 9 a.m.
Okay.
Mr. Sides?
I think the court just needs to make a formal
Hello, Beck. How are you?
finding the defendant is competent to proceed and send back in the Yuma County Court docket.
Sounds
Thank you,
good.
Judge.
That's what we'll do. Court finds the defendant is competent to proceed, and we're going to move you back to the originating courtroom. That's going to be Yuma County Court on July 22nd at 9 a.m. You will have to appear in person on that day. Okay, Corey?
Okay.
All right. Sounds good. Okay. Thanks for all your efforts.
Question.
Sure.
In the past, Mr. Jones was the judge and it's always been an issue. Is it not going to be Chris or a different judge?
It's going to be Judge Jones.
Okay.
Go ahead, counsel.
Mr. Freerichs, I will have your attorney, Soren Oberg, reach out to you and talk to you about your concerns, okay?
Okay.
All right. Thank you, sir. Have a good day.
All right. Thank you.
Oh, Cosmic, thank you for the gold coin. I appreciate it.
Yep, all the cases. They're all misdemeanor cases in Yuma County. Okay, Santiano Amaya?
I think I like Judge Blanco better. This judge is fine. Nothing wrong with this judge. I'm not complaining about this judge. I haven't been able to find Judge Blanco. But this is the other mental health court, so I put it on.
I saw you join us.
I'm his mom. I'm waiting for his sister-in-law to get home and get him on. I'm hoping within the next 5 to 10 minutes.
Okay. Do we have Victor Armstrong Brandon?
Victoria.
Yes, I'm here, Your Honor. Hi there, sir. My name cut off on my paper. I'm so sorry, Victoria. Court's going to call case 25M49 out of Washington County, People's State of Colorado versus Victoria Armstrong Brandon. We're here for a review. Counsel Schamberg is appearing on behalf of and with the defendant who appears by WebEx, Mr. Sides for the People. Okay, counsel, looks like might need an advisement.
Yes, Your Honor. We do, sorry, I was just pulling up my notes for this case. I did just want to confirm briefly with Miss Armstrong that her current cell phone number ends in 0476.
That's not what my number is anymore. I think I might need to update that.
Do you have the office, the number for the public defender's office, the number?
I do on a card.
Okay. Can you call my office and give us your updated phone number?
Yes, ma'am.
Okay, thank you. We do have a diversion offer we need to talk with Miss Armstrong about.
V, tell me the truth. Tell us all the truth. We won't be able to figure out who you are, so I'm not asking you for personal information. But have you ever appeared on an episode of Snapped? You have, haven't you?
If the court wants to give an advisement today.
No, they don't want to give an advisement. Is Snapped still on? Do they still make episodes of Snapped?
Hey, that'd be fine. I think also if she's going to diversion, we don't necessarily need that. If we want to set to August, we'll
do that.
Work it all out before then.
Okay, I think that's a good plan. You got a good plan going. I do have a couple questions for you, Victoria. Do you have insurance?
I have Medicaid.
Thank you. And are you a vet? Are you a vet?
No.
Okay, very good. Thank you. So I'm just going to set you over till August 11th at 1:30. And you can
let me write that down real quick.
Yep. Oh, thank you. And you can appear by WebEx just like you did today.
Okay. I don't exactly understand what she means or anyone means by advisement. What does that mean?
Oh, well, I was going to give you an advisement, but your attorney thinks that your case is going to go in a different direction, and they're going to talk to you about that. So, and give you some more information. So I'm not going to do the advisement today.
You know, Bobby, nobody in chat needs to see Snapped more than you. Not Snap, Snapped. You should watch like 30 episodes of Snapped.
Oh, everything's going fine. There was the evaluation that was ordered though, so yeah, you got it.
Yeah. And it was August what?
August 11th at 1:30.
1:30.
Exactly.
Okay.
Hello?
One moment, please, sir.
Thank you.
All right. Thank you, Victoria. You have a good day.
You as well. Bye.
All right. Bye-bye. Who dialed in on the 720 phone number ending in 74?
I did.
What is your name?
I did.
Santiano Ryan.
Oh, very good. Court's going to call case 25CR3, People of the State of Colorado versus Santiano Amaya.
It's a series of true crime stories where women finally had it. They had it. They snapped. And then lots of people die.
We are here for a review. Counsel Schamberg's appearing on behalf of and with the defendant who appears by WebEx. He does not have video. And Mr. Sides for the People. Counsel.
Yes, Your Honor. So Mr. Amaya is does need to get reestablished with outpatient restoration. He is not currently at Valor, and so I believe he was discharged. We do also need Mr. Amaya to contact my office so we can help him get back into compliance.
Mr. Sides?
Sorry, Judge, 1 second. My notes aren't. I'm slow getting to them.
Yeah.
this is his mom. I just wanted to chime in kind of quickly. My major.
No, ma'am, no. You're not allowed to. I'm sorry. You're allowed to observe, but not participate. He has an
Okay.
attorney who represents him.
Okay.
Thank you.
That's
Sorry,
unfortunate,
Judge.
V.
Forgive my
Being unsnapped was sort of a goal of mine.
delay.
That's okay.
Eileen, thank you so much for the disco.
Okay.
So I guess, Judge, I was just double checking the court liaison reports, making sure I wasn't missing anything. I didn't see a reason given for why the defendant was discharged from Valor, but it's possible I just missed it. But I don't see that it was given. So I don't know if he could be returned to Valor or not, because he was given a PR bond just to be in Valor, and now he's not there and he got discharged for some reason. So if the reason for the PR bond is gone, what? So I guess by August, we need to have a plan in place. The court needs to readdress bond at that time, is what I would say.
If the court is giving us, if Mr. Sides is giving us notice under 109 to address, bond can be readdressed at the next court date. We can work with Mr. Amaya in the meantime to figure out if there are alternate plans. Mr. Amaya, you need to contact our office, and Mrs. Amaya, Mom, you can call the public defender's office in Sterling. We will happily take any info you have.
Yeah, Mr. Amaya, the information that I have is that you were discharged, not successfully discharged, and that you're not participating with the Bridges program. You're not engaging. These are, restoration is a condition of bond. It is required. It's not optional. And the bond only allows you to be out if you are in Valor. So what we'll do is there'll be some investigation, and we'll come back on August 11th at 1:30. We will be addressing bond. And your attorney will give you more information.
All right, thank you.
Thank you, Judge.
Anything else? I think we're good. August 11th, 1:30.
Good day.
Will be addressed. Yes, absolutely. Leah Feller? Nope. I see Mr. Solero. Hang on just one second. Do we have David Oberly?
Joke's on them. We're going to snap anyway.
He has a flat tire. Okay. We'll call Mr. Solero's cases. Call case 24CR4, 25M59, 24CR12. These are all Yuma County cases. People of State of Colorado versus Arturo Solero. We're here for a review appearance. Counsel Schamberg appears on behalf of him with the defendant, who appears by WebEx, and Mr. Sides for the people. I had information he was in custody. That does not appear to be. Oh, he is.
He's at Peakview, which is custodial restoration.
Okay. Excellent. Thank you. Very, very good. Counsel.
Yes, so Mr. Solero is participating in the services at Peakview. We're asking to set over 90 days, and hopefully we'll have an updated report.
We've got a report on July 1st.
So I think
I think the plan was we have found a competent again, so that order a re-eval to have out in 90-ish days.
He's still found, we're asking the court to adopt the finding to continue to find him incompetent to proceed, to continue to order outpatient restoration. Theoretically, we'd have an updated evaluation in 90 days by statute. We probably won't, but.
We could do a review in 90 days.
Yes, review 90 days and for the court to issue an order for CHS to get us a re-evaluation approximately 90 days from today.
Issue that order today. We just got the evaluation July 1st.
We're supposed to get evaluations every 90 days.
I know.
It doesn't happen. I know.
So if we at least issue the order saying, hey, CDHS, we want another evaluation here in 90 days from today. We've at least done what we can do. And then if they don't do it, we can pass the blame on to them.
Okay, any objection to the continued finding of incompetent to proceed?
No, Judge, none.
All right, so the court will adopt the findings of incompetent to proceed. We'll continue in custody restoration. So what happens is when we issue these orders, we often get responses from CDHS, and they're not always pleasant. Court will order a reevaluation. And just brace yourself for a response.
What does that mean? What did it say?
All right, we're going to have you come back in 90 days. So it's October 13th at 1:30. Just call in like.
All right, she pissed me off when she set something for September, but now she's setting it for October. Ma'am, you need to slow down. You're going too fast. All those words burr mean winter. Let's just enjoy the summer for a bit, can't we?
Like you did today. And keep up the good work. I'm glad you're doing well.
Yes, ma'am.
Yeah, it's good to see you. You look good.
Yeah. Smiling now, like my voice keeps changing, and I feel like I got like some facial change too after a haircut, but I'm doing all right.
Well, your haircut looks nice.
Yeah, I'm trying to get back to my feminine look that I've had my whole life. So, I'll be back in 90 days. Thank you.
90 days. You keep up the good work you're doing, okay?
Okay.
All right. Thank you, Mr. Soleros. Good seeing you.
Yeah.
Okay, bye-bye.
We'll issue the WebEx, right, Judge?
Huh? October 13th.
Right, for
that would be great.
Yeah.
All right. Who else do we have? I just have Miss Feller and Mr. Oberly, right?
And Mr. Oberly.
Oh, he's late. He's
Yes.
got a.
Is he going to come here in person today or?
So the clerk from Phillips says Oberly called, he got a flat tire, he will be late, Phillips County, that's all.
Oh, okay.
So he's going to Phillips.
So he has been offered diversion. He is accepting diversion.
Oh,
we just need to get the paperwork completed.
Okay.
So the plan today was to set to August with the idea to vacate that court date once we have all the diversion paperwork done. And so if the court would waive his appearance today, we have good contact with him. So we can let him know this is your next court date. If we get everything with diversion done before August, we're going to change that court date to be 6 months out.
I'm happy to do that, but it sounds like he's.
Okay, we're going to reset it. That sounds great. Terry, love, I don't mean to shock you, but it's almost winter. So you're going to have to get back on your clothing drive train and get busy or people are going to be cold. Everybody send clothes to Terry. All right, we're going to move to Judge Cutie Pie. We're going to move on. Here we go.
There
he is.
It's very quiet.
Hi, Brett. Brett.
You tried talking.
Okay, good morning, folks. We're calling now 26 CR 1061, People versus Bustamante from the Division M docket. I'll take entries starting with the people.
Edgar Winslow for the people.
Reed DeChamp, 50734 on behalf of Ms. Bustamante, who appears to my right.
Thank you. This matter comes on for, I believe, for arraignments. Mr. DeChamp, how would you like to proceed?
Judge, I have not spoken with the assigned district attorney yet, so I would like some additional time to explore resolving the matter. I would ask for around a 6-week continuance.
Thank you. For the people?
Your Honor, we have no objection, and we are very compliant on a continuance.
Okay, thank you. I do find good cause to continue the matter for further arraignment. We'll set the matter in Division M. Mr. Champ, Ms. Winslow, how much time do you think makes sense on that?
I mean, I think roughly around 6 weeks, 7 weeks should be sufficient. I don't know what day of the week.
I think that's fine for us as well, Your Honor. And this is Ms. Coney's case, and she would prefer a Wednesday or Thursday if possible.
Okay, great.
Okay. Thank you. We'll continue the matter for roughly 6 weeks. We'll find a Wednesday or a Thursday.
So we did not bring him over. Okay. Thanks.
Can you pop your microphone?
That's easy. Thank you.
Okay, so we may have some issues with our audio. We'll just make sure, given the nature of the hearing, I think minute orders are sufficient as to no opposition on the continuance. We'll sort that out in between.
How's August 17th?
It's a Monday.
Is it Monday?
Did you say Wednesday?
Wednesday or Thursday, please. That'd be great.
Is that great?
August 12th.
That'd be great.
That works for the defense.
Okay, thank you. Bond will continue to that date. Anything else from either party?
Not from the defense. Thank you.
Okay, thank you, folks. Thank you, Ms. Bustamante, excuse me.
Nope, I'm crazy.
Morning, Ms. Eisenman. Are you ready on the McMaster matter?
Yes, Your Honor, we are, if the prosecution
Okay,
is.
thank you. Yeah, that's still really.
Your Honor, if we could hold off on that for a minute. The named victim is typically present in person, and it's 8:37, so I'd like to give her a couple of more
Okay,
minutes.
that's certainly fine. Thank you, Ms. Lansbaum. Ms. Eisenman, Mr. McMaster, give us just a few more minutes and then we'll call it once we're ready.
Thank you.
Monarch competency.
Thank you. I see that. Morning, Mr. Guyton.
Terry,
How you
I agree. I agree.
doing, sir?
I'm doing fine.
All right, thank you. We're calling 25 CR 1128. I'll take entries starting with the people.
Kendra Winslow for the people.
And Lisa Herbst appearing on behalf of Rachel Lanson, on behalf of Mr. Gaitan, who is appearing virtually.
Thank you. This matter comes on for arraignments. We have technically been waiting restoration evaluations out of another county. Ms. Herbst, do you have any updates?
Yes,
They're coming from-
Ms. Lanson said to set over after October 2nd for Douglas.
Okay, so no new evaluations at this point. Ms. Winslow, any objection?
Your Honor, I don't have any objection. So one moment, my
Sure.
computer is really taking its
Oh,
time.
that's why. I guess Douglas County is set on the 2nd.
Your Honor, just one of my concerns in this case continues to be that incompetency hasn't been formally raised in this case, only in the Douglas matter. And so I understand it's primarily procedural at this point, but I suppose I would ask for the court to make an initial finding of incompetency in this case, and then I would feel more comfortable continuing to trail this for that extended time.
Okay, thank you. Mr. Herbst, any position there?
No, Judge, I would just ask if that, would you like Ms. Lanson to file a motion?
I think at this time, I'm comfortable either raising that on the oral motion of the people or sua sponte on behalf of the court. We have been trailing other matters where competency has been raised. Mr. Guyton, to my understanding, has been found to be incompetent to proceed. I do find that I have sufficient information to find that Mr. Guyton is incompetent to proceed, but is restorable, at least at this time, without further evaluation indicating to the contrary. So I will order a stay on the proceedings pursuant to statute. We'll set the matter for review. I will order that we rely upon the evaluations that are already pending out of the other cases. Ms. Herbst, if you have those other cases, if you could provide those to Ms. Braswell. Otherwise, if you could have Ms. Lanson just provide those via email.
I have Douglas County case 23 CR 1274.
1274. Okay.
And that's who we're trailing.
Okay, thank you. We'll rely upon the evaluation being conducted there. We'll set the matter for further review. We'll find a date after. Did you say October 2nd?
Yes,
Okay, so date after that.
or October 13th.
Well, folks, I'm wondering at this point, I think it might make sense to just have this heard in the competency division.
I told Rachel that would happen. She goes, no, I don't think so.
I would be fine with it going to T.
I think she's fine with that too.
For the court.
So we'll send in T, but we'll find a date in October.
Thank you.
October 6th. I won't.
Sounds great. Thank you.
Okay.
Tuesday.
Thank you, Matter. Be set Tuesday, October 6th at 1:30. Allow Mr. Guyton to appear virtually so long as he remains at the Monarch Competency Center and is compliant with that program.
Thank you.
Thank you, Ms. Herbst. All right, thank you, Mr. Guyton. So you'll be back. It'll be a different division, so make sure to talk to Ms. Lanzin about and make sure everyone has the link, okay?
Okay.
All right, we'll see you back then, sir.
Thank you. Have a great day.
Judge.
Thank you.
Okay.
Ms. Lanzin, are you in the Stern cases? Okay. Morning, Ms. Stern. We are calling 3 cases, 19 CR 2366, 24 CR 347, and 19 CR 4996. I'll take entries starting with the people.
Kendra Winslow for the people.
Jessica Jones on behalf of Ms. Stern, who is present and out of custody on bond.
Thank you. These matters come on for sentencing. I believe the 19 CR matter is set for arraignment this morning. Ms. Jones, are you ready to proceed?
Yes, Judge.
Thank you. And Ms. Winslow, are the people ready to proceed?
Yes, Your Honor.
Okay. And I'm sorry, was there a plan as to the 19 CR matter?
Your Honor, that case will be dismissed pursuant to the plea agreement.
Okay. Thank you. Ms. Jones, I'll turn it over to you.
Thank you, Judge. There are no corrections or additions to the pre-sentence confinement investigation report. I found it interesting that they don't, typically there's a final section in a PSI that is a recommendation, and that doesn't exist in this report. I think in part it might be, and I don't know, but in part because Ms. Stern is doing so well that her scores are actually too low for the Women's Recovery Program, which we were hopeful she would be admitted to. But I think it actually is such a good sign that Ms. Stern is already on the right track. She's already doing the things that we want someone to do when they take advantage of those kinds of assistance programs like the Women's Recovery Report. Her LSI is medium, 20, and what's required for the recovery court is 29. Her treatment level is just a 2 at education, and what's required for the treatment court is a level 4. And I think what's noted in the PSI is that Ms. Stern is already doing the things that we want someone to be doing. She is in counseling once a week, sometimes twice a week. She is working full time. She was just recently granted a promotion to general manager at the restaurant that she manages. She is spending all of her time at work or with her family. She has her own car that she just told me she was able to get. She is taking care of her family, her mom, who she lives with, her grandchildren, who are her pride and joy. And I think it's what means that she is staying away from those temptations and what she's staying away from the things that derailed her, that brought her to this place. Ms. Stern is a success story. And it's someone that I have seen make this change through my representation and working with her. It was when bringing on a forensic social worker to work on a mitigation report that was provided to the prosecution to get to this offer that Ms. Stearns was able to find counseling and was able to get into therapy. And one of the things that she told me is that she is actually learning how to talk about the past trauma that she has sustained in her life instead of just bottling up her emotions. She's able to make that connection, that bottling up those emotions is what led to her keeping a distance from her family. Bottling up those emotions is what led her to turn to self-medicate with drugs. Those distances from the people who had her best interests at heart and instead turning to associates and drugs are what led her to these poor decisions. And Ms. Stern doesn't deny that. She doesn't deny that she has a criminal history. She doesn't deny that she has made mistakes and mistakes and mistakes in the past. But she wants you to know, Your Honor, that she's changed. She is someone that can now recognize the patterns that have led her into her life, and she is on the right track to do whatever needs to be done. She met with her probation officer. She met with the PSI. She is continuing to do well on bond. She stays in touch with me. She comes to court, and she continues to fill her time with positive things like work and family. I think that sometimes, Your Honor, those in the system, and by that I mean you and the prosecutor, can sometimes think that probation is such a gift, that it's not really a punishment at all, that there needs to be some kind of additional sanction on someone. But I want this court to know that every time Ms. Stern comes to court, it is an act that she feels shameful and remorseful about. The fact that she has to tell her employer that she needs time off, that she has to talk to her family about what might happen. These are things that bring her significant amount of stress and feel like a punishment in and of itself to deal with this case and to deal with it in a responsible way. It is not simply just a slap on the wrist to say to Ms. Stern, you need to continue to do the good things that you're doing. Because the good things that she's doing, Your Honor, are in fact work. They're effort. It takes time and intentionality for her to step up and say, it's not just that I need to do better in life, but I actually need to ask others for help. I need to actually put in the work to change. I emphasize all of this because I understand her criminal history, and it's my expectation that the prosecution, given the fact that she was accepted to community corrections, will be asking for community corrections. This is not an excuse, but I do want the court to know that from time to time, community corrections can be a setback instead of an opportunity for growth and change. Ms. Stearns met individuals there that she thought were her friends. When she was there in 2018 and 2019, those individuals that she connected with, that then she lived with when she was working her way into the community, helped derail her with drugs and poor choices. The people that are going to help Ms. Stern and keep her on the right track are here in the courtroom today. She is here with her mother, her sister, her 2 grandchildren, and her sister's husband. They're here to show you, Judge, that they also are committed to making sure that Ms. Stearns does, that they support and they see the change in Ms. Stern. Because there was a time in her life where these family members did not engage with Ms. Stern on a regular basis. They saw the track that she was on, they saw the trouble that she was in, and they couldn't make her change. She had to change herself, and they saw that she wasn't ready for that, and so they kept their distance from her. But they're here today to say that she has changed and that they do see that and they recognize it and they support that. And I emphasize that because I want the court to know that she absolutely has the support that she needs to continue on the right track. Recovery programs, recovery court would be to help someone get to that right track. And Ms. Stern is already there. As I said, if she were to go into community corrections, it's not sure that she would be able to maintain her job and her promotion. She now has car payments that she's working towards. She's the sole caretaker for her mother. And I think that she is also, as I mentioned, in treatment where at this moment she's talking with her counselor about going to the gravesite of her nephew. It's mentioned in the PSI, that very traumatic experience that she had, and it's something that she's never been able to discuss or process. But with the help of weekly therapy, Ms. Stern is really, truly a different woman. And I can say that I've seen that change myself in the course of my representation with her. This court might recall that these cases took a bit longer than usual to resolve and to get to this place. But as a result of that, I have seen genuinely the benefit that counseling can provide for someone. The ability for Ms. Stern to talk about her past and her trauma is something that she did not and was not able to do when I first met her. And even this morning when we were sitting on the bench reviewing what we were going to say today, Ms. Stearns interrupted me to say, I want to thank you and Megan, the social worker, for helping me get to this place. Something that I hold dear because it's not something that I hear from clients, but I think it's worth mentioning.
Okay. I agree with one thing you said. Coming to court for her is a punishment because you keep talking.
To you, Your Honor, because it shows just how impressive the change and the growth that Ms. Stern has displayed. That she's able to stop and pause and say, I'm a different person, and I'm grateful for your help in getting me to this new place. I'm happy to answer the court's questions. I'm happy to address any specific concerns, but I think the most important, compelling point that I think is for the court's consideration is that Ms. Stern is already on the right track, and that is why she was not admitted into recovery court. I think that speaks volumes about her ability to be successful on probation and why it is that community corrections is not necessary for this specific individual.
Thank you, Ms. Jones. I don't have any questions at this time. Thank you. Ms. Winslow.
Thank you, Your Honor. Your Honor, I think candidly, my recommendation in this case is a close call. Me and Ms. Lamson have had the opportunity to talk several times throughout the pendency of this case, and the presentation of her social history and the work that she'd been doing while these cases were pending is in large part the reason that we reached this more mitigated offer to plead guilty to the F4 theft rather than the F4 ID theft. I think it's important to note that due to the date of offense in these cases and a prior ID theft conviction from 2012, she would have fallen into a position where this would have been a mandatory DOC case in the aggravated range given her prior history. Her history here is, I think, what is most concerning to the people and which gives me the most pause to joining in a probation recommendation. Ultimately, I am asking the court to impose a COMCOR sentence. In a review in her criminal history, she has an extensive history of similar conduct. And the PSI shows clearly that she has never been successful on an opportunity she's been given for community-based supervision, for probation, for deferred judgment and sentence she was previously given. And in each of these cases, without fail, she's either been revoked and terminated to COMCOR or revoked and terminated with a jail sanction to be imposed. I think it's also significant to emphasize that when she picked up these cases and throughout the pendency of them, she had several other pending felonies, including in Broomfield County, again, for ID theft. This has been something that is a clear pattern and seems to be endemic in her history and something that has no small impact on the community and the victims who have been impacted by these thefts. She incurred financial liability on behalf of these victims. She used their identities. She caused, an immense amount of insecurity and worry and effort on their parts to try and reclaim their identities, reclaim their security, both personally and financially, to be able to move forward from these offenses. And so I think while we tend to think of these crimes as not being victim crimes, they certainly do have a substantial impact on those people and the way that they have to move forward beyond it and the work that they have to do in their lives to create that security again. And Your Honor, one thing that did give me pause in the PSI is I think her representation, or her own representation regarding her response to supervision and her previous history with drug use. Throughout the pendency of this case, a lot of her social history that has been presented as mitigation has revolved around the fact that she has had this consistent drug problem that's been related to her trauma. However, in the section regarding specifically drug use in the PSI, it seems to be very, I don't want to say mitigated, but it seems to be minimized, the amount or the accountability as it relates to alcohol and drug use, saying that it's only been between 26 and 50 times in her lifetime for use of each of those substances, which I don't think is consistent with what is represented in her history and what's been argued for her social history. I think that this is a person who continues to require a lot more accountability regarding her past history and her use of controlled substances and how that has added to her struggles in this present case. I think with an acceptance to COMCOR, that is the most appropriate sentence here. I think that her history is severe. And while I recognize that she's made a lot of efforts in the community and she has been making good progress forward, I do continue to be concerned that this is a person who has historically never once been successful with this type of sentence. And just the posture of this case is one in which she would have had mandatory DOC had we not come to a much more mitigated offer, which did take time and reluctance, candidly, because of
Wait, so why are you saying all this, lady? You made the offer. She accepted the offer. I don't understand what you're trying to do now. You made the offer, she accepted the offer, and then she did well. I I don't know what's going on. Remember when Bill got hacked and got his whole account stolen? Oof. Oof. That was terrible.
The severity of the history here. I do think that ComCore is the appropriate middle ground for sentencing here to provide both accountability and oversight, the continued treatment she needs, the assurances that she'll continue on in these programs that she's currently engaged in, and keep her success moving forward in the community. So I would be asking for the court to impose a ComCore sentence here.
Thank you. Ms. Stern, anything you would like to let me know?
Your Honor, if I may, before turning to Ms. Stern, I just wanted to emphasize that this was the big sticking point was the age of these cases and when they were filed and the date of offense. That is the case that the law then would have required mandatory DOC. But that law has since changed. That is no longer a requirement in the law. And part of what happened here is that these cases, while filed back in 2019 and then in 2024, Ms. Stern was not aware of the pending cases. It's not as if she was on the run from these cases. She didn't know that there was a warrant out and active for her. At the time, in 2019, that would have been the requirement, but that's no longer the requirement, that there would be mandatory DOC, an indication that the legislature even recognized that that is a harsh situation for these individuals to face. And I just wanted to emphasize that timing given the prosecution's argument.
Thank you, Ms. Jones. Ms. Stern.
I admit that my past was not the best. Ever since I've been out of ICCS West, I have came far. I went from sleeping under in the streets from sleeping in the streets to having nothing to now I have everything. I've worked so hard. I continue to go on. I have therapy once or twice a week. I even text her when I have questions or when I feel like I need to talk, and she's always open for me. I have learned a lot about myself. I've learned how to discuss past things that have happened to me that I've never talked about. I don't drink. I have never really had a problem with drinking, and I've been clean. I go to work 6 days a week. I have 1 day off a week if I get that lately. With my new promotion, I'm always at work, or with my grandbabies, they're over all the time. They're my world. But how many people can say they went from having nothing to gaining to slowly but surely gaining everything back? I've worked very hard to where I'm at now, and there's nothing that's going to stop me to go back. All I want to do is go forward and to be a better person that I know that I am. I've worked so hard, and I'm not going to let anything. I have my own car now. I have my own place. My mom lives with me. I help take care of her because I just recently lost my stepdad and my dad. I took care of my dad, and everybody thought I wasn't going to. I stood up because of how my past was. I face challenges every day of having to prove that I'm not that person anymore. And I do it, and I overcome them every time. My family was so proud of me to see how well I stepped up to the plate with my dad. I was there every single day. I did all the planning and everything. I helped my mom with my stepdad that has been passed away a little bit over a year now. I have faced those challenges, and watching a parent go from walking, talking to a vegetable is the hardest thing. But I continue to grow. I continue to, nobody's told me that I had to go to probation to therapy or anything. I did it on my own. I've been going for 9 months now, consistently, to where I'm finally figuring out who I am and who I want to be. And it took me a long, long time to be able to talk about some of this stuff, because I would never talk about finding my nephew or any of that stuff. That's the hardest thing. And I just continue to grow, and I'm doing it on my own. I'm always showing everybody. Before, I wouldn't have came to court, honestly. I made sure I've been here to every single court date. I went to do my PSI sick. I was so sick. I was running a high fever, but I still went. And they sent me home right away. I'm showing my effort by doing it, and that's all I can do is keep continuing to grow. And I feel like I'm doing what I need to do. Thank you.
Thank you, Ms. Stern. Thank you, folks. I've considered the arguments of both parties. I've reviewed the files in each matter, including the pre-sentence investigation report and community corrections acceptance letter, as well as the denial for a problem-solving court, as noted by Ms. Jones, given Ms. Stern's lower risk factors and treatment needs. These cases do involve, as noted by Ms. Winslow, and I think conceded by Ms. Jones, multiple instances of very similar conduct between these cases, as well as similar to the prior criminal history for Ms. Stern, including 3 prior felonies, one of which did result in a community corrections sentence. And the amounts here certainly are not insignificant. And as Ms. Winslow noted, even though these are considered property crimes, certainly there are real victims here and real consequences for them. And I imagine somewhat of a nightmare to navigate correcting the harm done by Ms. Stern here. Looking at the pre-sentence investigation report, most of Ms. Stern's protective factors, the objective measures here are in the protective range. Her criminal history, some pro-criminal associates, which was addressed by Ms. Jones somewhat, and the emotional personal factor was in the elevated range, indicating some risk. But it does sound like Ms. Stern has taken some efforts on her own to address that through counseling. And her LSI score was at a medium, again, indicating that she was not high risk or high need enough to warrant consideration for the problem-solving court. Part of my consideration here is accountability for the criminal conduct here, particularly in light of the prior offenses. But I also must consider where Ms. Stern is at now. Prosecution's concerns about Ms. Stern's compliance with probation is certainly fair given her prior history. But it does sound like Ms. Stern has done a lot of work to develop stability factors that may put her in a different position at this time. She is working full-time, has family support now in the community, owns a vehicle, and has a lot at stake now that it sounds like was not the case before. So I do share the concerns with Ms. Jones noted of community corrections or Department of Corrections disrupting that stability and trajectory. Certainly look solely at the harm done by Ms. Stern here and the prior criminal history. Incarceration would be warranted, but I also want to make sure that Ms. Stern is in a place where this never happens again and she can continue on the current trajectory. So sharing some of the hesitation noted by Ms. Winslow, I do find that a probation sentence here is appropriate.
I do too. Hi, Margaret. I think since she did so much work, I agree.
I will sentence Ms. Stern in each.
Although I hate identity thieveryers. I can't stand them. They do such harm.
Case to a period of 3 years of probation that will run concurrent to each other. I will order a substance abuse evaluation and treatment as recommended. Ms. Lindsay, what is the status of restitution on the new matter?
If I give just a moment, I believe we know the specific amount.
I just didn't see it marked on the Rule 11 one way or the other.
I do see that in the 19 CR 4996 case, the victims had requested 160 in restitution in that matter. I'm happy to follow up with filing with the court.
Okay.
Your Honor, I actually do have notes of that. I'm happy to agree to that at this time without the prosecution taking the next step of filing something.
Okay, thank you. Out of 19 CR 4996, I will order $160 to Patricia England as restitution. That will become part of the sentence. And it's sorry, I am. So Ms. Stern, I want you to be focused primarily on what you're working towards, maintaining what you have and continuing to grow. But given the prior criminal history, I do think a suspended sentence is appropriate as well. So I'm going to suspend a 6-year Department of Corrections sentence in 24 CR 347 upon compliance with probation. I will dismiss 19 CR 2366 as well. So sentences and judgment will be final. Any bonds will be discharged. I know, Ms. Stern, you have a Broomfield matter coming up as well. Obviously, I don't control what the sentence will be there. And Judge Vasquez will have to make her own determinations on where things stand. Ms. Jones, anything further?
No, thank you, Judge.
Thank you. Ms. Winslow, anything else?
No, thank you, Your Honor.
Okay. So, Ms. Stern, we'll have some paperwork for you to sign before you go. It's the terms and conditions of probation. Once you've done that, check on probation on the 3rd floor to get your supervision started. Okay.
Okay, thank you.
Good luck to you, ma'am.
Thank you.
Your Honor, if we could call the McMaster matter.
Thank you. All right, we're calling 25 CR 624, People versus McMaster. I'll take entries starting with the people.
Mike Whitney and Eleanor Lansbaum for the people.
Hillary Eisenman on behalf of Mr. McMaster. He is present. He's probably just turning on his, there he goes, turning on his camera.
Thank you. I do see Mr. McMaster on WebEx. I believe you had prior authorization to appear via WebEx if the evaluation had not been completed. My understanding is we are still waiting on assignment to an evaluator to complete the evaluation. Ms. Eisenman, how would you like to proceed?
Your Honor, we would just like to set over again for that evaluation to take place. I do think setting it out at a minimum of 60 days would make sense, although it still could be longer than that.
Thank you. Mr. Whitney?
Your Honor, just 2 things I want to talk about. Obviously, this delay is very frustrating. The court's order has been in place since February. I think the court made an initial order in December. I just want to make a brief record on speedy trial here. The first time the people asked to set this case for trial was about a year ago. It was June of 2025. Defense counsel has changed since then. The most recent time was November of 2025. November of 2025. And then counsel raised mental condition at the December court date. So we've made efforts repeatedly to try to move this case forward to trial. We've looked at options for trying to expedite the state hospital procedure. It obviously took me a little while even to get a response about where things stood, and the response was, "We'll tell you when we're doing something." So that's all very frustrating. But I do want to make the record that this delay is not something that the people are seeking, and it's actually something that's harming the people as we go along. The witnesses are moving, changing contact information, that sort of thing. We're trying to keep on top of that, but that just happens naturally over time. People change jobs, leave law enforcement. This delay harms us, and we're not seeking it. I am asking, I don't know if logistically the court can order a liaison or somebody who can maybe get us better information from the state hospital about what the delay is and where we stand. I obviously have been able to get emails back. If the court can order something like that, that may help here, but I'm not sure if Bridges is an option here, just given that this is not a competency case. The other thing I wanted to raise is that I know from handling competency cases that the state hospital sometimes has an issue if somebody is living out of state, and I know Mr. McMaster is living out of state. They will conduct evaluations by video conference, but they, in the past, have told me that if somebody is out of state when they try to conduct an evaluation, the evaluators are not willing to do that because that person, the patient, whatever you want to call it, the patient is the only term I can think of. They are in Mr. McMaster's case in Arizona, and the evaluator is licensed in Colorado. So
if they don't have a license in the state where the person is actually located when they do the evaluation, they believe that they are practicing without a license. So I asked them about the logistics of that, and shocking no one, I haven't had a response about what logistics would be required to get this evaluation done. So I wanted to raise that and put those issues on the record. I guess what I can say at this point is, based on my past experience, it may be the case that Mr. McMaster has to return to Colorado for the evaluation. But I haven't had a response about if that's still the thinking at the state hospital or what the logistics of this would be. All right. Thank you, Mr. Whitney. Thank you, folks. Unfortunately, at this time, given the backlog of the state system and lack of action this time, statute does require that there be such an evaluation before any mental condition evidence is, expert mental condition evidence is presented by the defense. So I do find that I have to continue the review. The expressions of frustration on behalf of Mr. Whitney and Ms. Dotson and her family is completely fair. This case has been pending for a significant period of time. And I'm sorry for the continued delays. I can't imagine having to come back here over and over again just to be told that we're going to wait longer, and there's really been no progress. Unfortunately, we do need to conduct the evaluation, so I will continue the matter. We'll continue roughly 60 days. Just to clarify, conditions of bond, in case this was not made clear previously, condition of bond for Mr. McMaster, is that he completes the evaluation and comply with any directions of the evaluator. That will include, Mr. McMaster, if you're not able to complete the evaluation virtually out of state, you will have to travel to the state of Colorado to complete that evaluation and work with the evaluator to accomplish that in a timely fashion. Ms. Eisman, any further record as to that?
Your Honor, I agree with everything you said, and Mr. McMaster has already, I think when we raised mental condition, we told the court that he would come back to Colorado for that evaluation. He has to come back to Colorado periodically anyway to have his GPS monitor checked and make sure it hasn't been tampered with. So he is quite used to doing that. And frankly, he also would like the case to move forward. This is not something he has chosen. We are trying to comply with the statute, as the court noted. 168107 requires this. Mr. McMaster also would like to have the case move forward. So, you know, it's unfortunate, but this is the situation we're in.
Okay. All right. Thank you, folks. So we'll find a date in roughly 60 days. Is there a particular day of the week, Mr. Whitney, you prefer? Your Honor, would the court consider setting it in 30 days, just so we can get a status on this case? And if the court appoints an evaluator, we can, or an evaluator, I would like the court to appoint an evaluator, but I was thinking a liaison. Okay. Thank you. If the court appoints a liaison, we can see the status in 30 days. Okay, we'll set in 30 days. I'll authorize a virtual appearance for Mr. McMaster and Ms. Eisman, and I will provisionally appoint a bridges liaison, and we'll look into whether or not such an appointment is permitted based upon our current setup. So we'll look
Your
at
Honor,
Ms. Eisman.
It's fine to do another court appearance. It's just we're going to keep doing this. I'd appreciate if we could just call it right at 8:30 then, if that's the case, and just, you know, be expeditious with our time if we are going to keep doing these appearances every 30 days. Okay, we'll list the case as a priority and do our best to expedite that along with the court docket that day. Thank you.
Is there a certain day of the week that works best for everyone?
Monday would be fine for us.
How's Monday, August 10th?
Monday, August 10th at 8:30? Can accept that.
That will
Thank
work.
you.
That works.
Okay. All right. Thank you, Bond. We'll continue to Monday, August 10th at 8:30. Mr. McMaster and his counsel may appear virtually. Ms. Eisenman, anything further at this time?
No, Your Honor. Thank you.
Mr. Whitney, anything else for the people? No, thank you. Okay. All right. Thank you, folks. We'll see everyone back then.
Thank you. Bye-bye.
Thank you. Yeah, and then let's trigger the appointment and see who's done. Perfect. Thank you. Ms. Herbst?
Judge, I am ready on, I believe, New Beginnings is up there.
Yes.
And my hope is that Jesse Bell is appearing.
Okay. I will going to unmute the Jackie Medina at New Beginnings. Do you have Mr. Bell with you there?
Yeah, I'm on here.
Okay, good morning, sir. This is 25 CR 2568 and 26 CR 313. I'll take entries starting with the people.
Winslow for the people.
And Lisa Herbst, appearing on behalf of Rachel Lanson.
Thank you. These matters come on for arraignments. Mr. Bell appears virtually from the New Beginnings program. Ms. Herbst, how would you like to proceed?
Judge, Ms. Lanson is asking to continue the arraignments on both cases. That's her request. And I would just note, as the court stated, that he is doing inpatient treatment at New Beginnings.
Thank you. Ms. Winslow?
Your Honor, ultimately, I have no objection to one more continuance here. I think we are getting to the point where we need to consider potentially setting for trial, but because Ms. Lanson's not available this morning, I have no objection. I can represent to the court that we are actively still having negotiations and conversations regarding this case, including the mitigation that he is currently in treatment. I would like to raise his noncompliance with SRP. He has missed several check-in calls, one office visit, and had one positive UA. I recognize that he's in inpatient treatment at this time, but I would just like the court to remind him that he continues to have that obligation as a condition of his bond.
Okay. Thank you, Ms. Winslow. Thank you. I do find good cause to continue the arraignment in both matters. I do agree with Ms. Winslow. We're on a third arraignment now. Parties should anticipate the next court date being a final arraignment and setting the matter for trial if there's not a resolution at that time. Noting, I did have some concerns about the SRP report as noted by Ms. Winslow. Those are somewhat mitigated by the fact that Mr. Bell is currently in a treatment program. But Mr. Bell, you need to understand, one, you still are on bond. Condition of bond is the SRP, which includes making check-in calls, as well as submitting UAs, and ultimately it'll be up to you and Ms. Lanson if you're taking UAs at the New Beginnings program to coordinate with SRP. If those UAs are at the same frequency of 4 times per month, I'll authorize those to be submitted in lieu of independent UAs, but those will need to be provided directly to SRP, and Mr. Bell will need to sign any necessary releases to ensure that that information is provided so we can ensure he is complying with bond. Ms. Herbst, any questions as to that?
No, Judge, thank you.
Okay. Thank you. We'll find a date in roughly 30 to 45 days.
August 10th at 8:30.
Monday, August 10th at 8:30?
That works for defense.
Works for me as well. Thank you.
Okay. Thank you. We'll be back Monday, August 10th at 8:30. Bond will continue in both cases. Mr. Bell, the assumption right now will be that you appear in person. If there's a reason you can't appear in person, talk to Ms. Lanson. She'll need to file a motion or talk to the district attorney before that. Otherwise, plan to appear in person at the next court date, okay?
Okay, Your Honor. And also here at this program, I take 3 UAs a week, Monday, Wednesday, and Friday. My case provided all those to my defense team, to my probation, and to SRP. So I'm not sure why they haven't presented that to them yet.
Okay. So the minute orders will now show that if you are taking UAs there, that will suffice for monitored sobriety with SRP, but Lanson may need to reach out to SRP to make sure that's actually happening.
Okay.
So hopefully we'll get that sorted out, but make sure you're in touch with Ms. Lanson to get that sorted. That'll be on you and her to ultimately make that happen, okay?
Okay, thank you.
All right. Thanks, sir. Okay, we'll see everyone back then. Bond will continue. Thank you, folks.
Bond will
All right, take care, Mr. Bell.
Yeah, you
Got it. Morning, Mr. Gonzalez. This is 25 CR 195. I'll take entries starting with the people.
Kendra Winslow for the people.
And Lisa Herbst, standing in for Rachel Lanson on behalf of Mr. Gonzalez.
Thank you. This matter comes on for continued arraignments. Ms. Herbst, how would you like to proceed?
Judge, I know that Ms. Lanson has a plea offer in this case that I think Abel and her have discussed, and we're going to take this morning, but I think Rachel wanted to be here and present with him for that, which makes sense. So I would just ask to set this over maybe 2 to 3 weeks.
Thank you. Ms. Winslow?
Your Honor, that's my understanding as well. Ms. Lanson did let me know that she preferred to be present with him personally. We've offered a deferred judgment to menacing with a straight plea to the M1 assault 3 in this case. I have provided them paperwork of that since I've looks like about 2 weeks ago. So I'd have no objection to one more brief continuance here.
Okay. Thank you. I do find good cause to continue the matter for a final arraignment. We'll find a date in roughly 2 to 3 weeks.
Thank you. How's July 20th?
That works for me. Yeah, sorry.
That works.
Okay. Thank you. Bond will continue to Monday, July 20th at 8:30. Anything else?
Well, we got to see Judge Cutie Pie today, so that was good. Guys, thank you so much for coming out this morning. I really, really, really appreciate it. I shall see you all in 22 hours. I'm going to live stream tomorrow morning because I don't work today. So, but this week is really, really busy for me. So don't be surprised if you log on to some premieres this week instead of some live streams. There's just not enough hours in the day. But we'll see. We'll make it through this week, one day at a time. All right? Behave, and I'll see you all again very soon. Bye, guys.
Well, I thought I'd write a happy song. I found a chat room where I belong. You don't know how much it means to me. With such a groove, I'm less lonely. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcome and play. I can count on distraction from my pain, 'cause this creator takes you there and back again. Kathy is the heart here, always in stride. Her work is hard, but her joy she can't hide. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her style is classy, she's always top shelf. Don't take my word, come and see for yourself. Her cases are new with a twist or two. I really like them, I believe you will too. A little lifeline passed along in rhyme. Why don't you join us? It's a guaranteed good time. Oh, Kathy's the creator, she's leading the way. At Court Vibes, we laugh and we stay. Her smile shines bright, she's got that grace. Come join the fun, it's a welcoming place. And so in conclusion, I'll wrap up this song. I hope I didn't miss anything that would be wrong. Hope I see you around. Don't stay on the shelf, join in the laughter. Come and see for yourself.